fire. Yeah, man. Hot pants and back James. This life's gonna take you higher. Find the keys and Joe. Talk about David. Take your big band master on straight out of here. You gotta.
Hi, this is John Klotz, host of Money Talks Media. Welcome back. We've got our good friend Maureen Tabuchi here. She is a lawyer, and we are discussing will and estate planning. And thanks, Maureen, for joining us today. We're certainly getting a lot of great information.
Pleasure to be here, John.
It's great. I wanted to talk about a couple of things. I want to talk a little bit about living wills and powers of attorney. But I'd also like, and we were talking during the break, to hear about some of the things that can go wrong in will and estate planning and some of the things you've seen. So go ahead. The floor is yours.
Okay. When you have a properly drafted will, everything flows the way it should flow. And there's a clause, a really important clause in the will that deals with the residue of your estate. So you're going to, no matter what you own at the time you pass away, it's going to go to whoever you choose. Now, I had a situation where a client came and said, well, I downloaded something and I've filled it in. So if you don't mind just having a look at it. And we were doing a real estate deal, so it was probably this person wouldn't have come to me if it hadn't been top of mind anyways. And I just, and John, I'm talking about an educated person here, okay? And what happened, I read through the will and I was like, ha, funny, you got me. There were so many mistakes.
Really?
I honestly, I thought it was a joke. I thought that it was just because the perfect thing, and out of a mess comes something perfect always. The perfect thing is that this is an example of what not to do in a will.
Okay.
So, first of all, if you are tempted to ever do your own will, you can't just say who's going to get what, because you're missing all the things that you're going to accumulate during your lifetime. Okay. Also, you can't just say to my children, because they're going to get all of your assets when they turn age 18. Okay. You have to set up a trust for your children. What are some of the other things? You have to make sure that that you have backups, because if you only provide an executor, one executor, then it's as good as not having a will if that executor is not around.
Really?
Okay, because then there's a court appointment that's required to appoint an executor.
Which was the whole idea of having the will, to avoid the courts.
Exactly.
Okay.
Exactly. Yep.
Okay. Interesting. I'm not surprised. And I'm sure in your practice you see the good, the bad, and the ugly.
Definitely.
So, okay. All right. So things can go wrong. That's why you need to go and speak with your lawyer. Let's talk a little bit about living wills, powers of attorney, that sort of stuff. What sort of thoughts do you have on those
right.
on those programs?
First, on terminology, because
Yes.
a lot of people say, oh, I'd like to do a living will, not a power of attorney.
What's the difference?
Well, in fact, they are a power of attorney for personal care.
Yes.
Is a living will.
Okay.
And it's also called an enduring will, and it's also called a continuing power of attorney for personal care. So those things are all one and the same.
Okay.
Basically, what a power of attorney for personal care is, you're giving permission for somebody else to make your healthcare decisions.
Yes.
If you're not capable of doing it yourself. So if you're mentally incapacitated in any sense of the word, or if you are physically unable to make decisions, then it would kick in as well.
Okay.
Right. So, and then some people say that they would like a doctor to make the decision about whether they're mentally incapacitated. Because, as you age, people who are starting to lose capacity, some days they're good and some days they're not so good. So, and that's the job of the lawyer, is to determine, and in some cases it comes down to them actually giving a formal notification that I did ask some questions and I did determine that they did have capacity to sign this document.
Interesting. What are some of the things people need to consider when setting up their power of attorneys? Like, what is it that they have to consider?
Right. So now there's the power of attorney for personal care, and then there's the power of attorney for property. So property is it's a lot like the will, John, because you're deciding what's happening with your stuff. It's just that you haven't passed away. You're still alive. Mm-hmm. You're just incapacitated. So usually the same people who are the players in the will are going to be in the power of attorney for property as well. So maybe your spouse, and then a backup after that. Now, the power of attorney for personal care is very different. And here's again where my personal bias comes into it, because power of attorney for property, I always recommend just have one person. Don't have more than one person, because it's kind of the case of too many chefs in the kitchen can spoil. And you may be asking for litigation for dispute, and always have a mediation clause in your will, just in case there is some disagreement. Heaven forbid you want most of your estate going to the lawyers to, in some legal battle.
What does the mediation clause say?
It just says that if there's a disagreement, the parties will go to mediation before they sue the heck out of each other.
I see. So you're giving them an option not to go to court.
It's actually not an option. They must. They must do that.
Okay.
Yeah. So so one person would be appropriate, in my opinion, as a power of attorney to deal with your property.
Yes.
Now, personal health care decisions, I believe, is different. And that's where name the whole family, and they can agree between themselves what's best.
This is whether or not to pull the plug?
Yeah.
Is that some of the things they talk about?
Yes, exactly.
Okay.
Do not resuscitate. Treatment, given terminal illness.
Yeah.
Yes.
Okay. So you're suggesting at that point that it not be one person, that it be sort of almost a committee of family members. Is that accurate?
That's my viewpoint.
Okay.
Now, of course, it's the individual's choice, but you have a choice. You can have your spouse often is a good one, and then after that, how would you choose one of your children over the other? As far as making personal health care decisions.
Yeah.
Now, that may make sense for money decisions, because maybe the oldest one would make sense, and on down the line. But personal health care decisions, it's often a good idea for the whole family to be making those decisions together.
Okay, fair enough. And I'm sure there's anything else you want to say on living wills and powers of attorney that you think is relevant?
No.
Okay, well, that's an honest answer. Gee whiz, a lawyer's short on words. Wow, oh boy, first on Money Talks Media. In this whole topic, it strikes me that you can do a will and leave your kids with money and have everyone live happily ever after. At the same time, you can do it so everyone hates each other.
Yes.
And that's that strikes me that there's got to be some way to do it. Potentially, maybe you favored one child financially during your lifetime over the other, or one's richer than the other. What do you do in situations like that? What kind of advice do you give your clients to sort of even the playing field, so to speak?
Wow, that's a good question.
That's why I asked it.
There's a movement now towards having a free, open meeting, family meetings. It's coming from the States, and I believe probably from California, where they eat a lot of wheatgrass. But you know what? I think it's a good idea, John, because the family who's making these types of decisions together is going to not have any. It's going to be very seamless on the next generation.
Right.
And how they take money, and maybe they're taking over a business, or just maybe there's just money. But the other end of the spectrum is this very secret will that isn't read until the testator passes away. If someone comes into my office and says, listen, I have 3 children and I want to leave everything to one and cut out the other 2.
What do you do with that? That's got to be a tough call.
I need to start asking some questions.
Yeah.
And if there's a valid reason, then you need to document that. And so it's going to be the case of that person wasn't just totally senile and just decided to cut someone out, but there was a reason for it. And so that's going to, if it ever does come to court, and there's under the Dependents Relief Act, actually an adult child doesn't have a right to an inheritance, but if they're a dependent, they do. So there's the legal aspect of an unfair will, and then there's just the hurt feelings and being kind of left out in the cold, whereas maybe you were expecting otherwise aspect of the will. And a well-documented set of notes in the lawyer's file is going to save a lot of time in court potentially if the reasons are known as to why there was an uneven distribution. Because
they'll come after you as the lawyer who set it up. They'll say, "How did you?" Right?
Yeah.
Okay.
Yeah.
Tell me something in terms of people have disabled children.
Yes.
What can they do in a will to sort of? I know there's Henson Trust and things like that.
Yes.
Go ahead. Maybe you can illuminate that topic for us.
Sure. Okay. I guess it's important to understand why a Henson Trust.
Mm-hmm.
A Henson Trust it's not incredibly different from a lot of other types of trusts. A trustee takes care of the assets, and the beneficiary, the disabled child, only has a right to what the trustee says they have a right to. So the whole purpose of it is the disabled child does not own the assets. Okay.
Right.
Now, why is that important? It's important, John, because disabled children often qualify for benefits from the government.
Right.
And those benefits depend on their net worth.
Right.
And if they are seen to own all the assets that they inherited, then they're not going to qualify for the benefits anymore.
Right.
Yeah.
Right.
So that's it in a nutshell, and that's why it's really important. Also, because if you have a disabled child who's given this whack of money, then someone has to step forward, and often it's the public guardian and trustee, and you really want it to be someone you trust, not a stranger from the government.
Okay. Great topic today with our good friend Maureen Tabuchi, and we've been talking about wills and estate planning. We're going to take a quick break. We're going to come back, and we're going to switch gears a little bit, and we're going to talk about real estate and legal implications of purchasing real estate. We'll be right back. This is Money Talks Media.